Hello, everyone. How good is Digital Adelaide, right? Thank you. This is what we need. I mean, it's a long time till Fringe. We need to remind ourselves what it's like to be in an audience. So I'm glad you're all making me feel at home on a stage with very little people in the front rows because they're very scared of me. Now, I'm just going to let you know, those of you who were thinking, should I be in this room or should I go to the B2B? You've made the right decision for one reason and one reason only. There are prizes in this session in the form of fun-sized Milky Way bars that have been sitting in my pocket and are a little bit melted. I'm looking after all of you. So, as usual, today I'm just going to be talking a little bit about the law, what's happened in the last 12 months. The world's been pretty chill, I think we'd all agree. Not much bad that's happened. And before I get into that, I just need to go through the one legality, which is, yes, I'm a lawyer, but this is not legal advice. Do not rely upon it. Talk to a lawyer. This is all just fun and nonsense. If you need a lawyer, you can come have a chat to me now. Those of you who've seen me present before, excellent. I'm sorry, firstly, that you're having to go through it again. You would know that generally when I get to this slide, it's some kind of terrible Microsoft Paint commission. Well, this is the 10th year of Digital Adelaide, and I decided it was important that I professionalise my presentation, that I really deliver to marketers what you expect to see. I'd like to have a shout out to the wonderful Julie Camilleri from Warmans who helped me set up this presentation, made it look very pretty, very professional, very appropriate. For now, I'm sorry, Julie, I just couldn't. The people want the bad Microsoft Paint, and this is what I'm going to give to them. So, I hope you appreciate you can see the cutout of the ear, which in Microsoft Paint is really hard to do with that little wand tool. So I do hope you appreciate the 10 minutes I spent preparing that. If you do have any questions on anything that I cover today, you can ask in the Slido, so make sure you have that up, or you can reach out to me on any of those platforms or just come hassle me afterwards. So today we're going to recap the basics. We're going to go through some issues and changes in privacy. We're going to look at AI, defamation, a really interesting and concerning story about ClickWrap, and talking about my favorite topic of all, Elon Musk. So, those of you who've been here before will know what we're doing now. This is the quiz night portion of the presentation. If you would like to win a partially melted Milky Way bar, now is your chance, so stand up please, because we're going to be playing a game of heads and tails. I have 2 Milky Ways. If we do not eliminate everyone, you all have to share. So this is just basically to set a baseline and remind you of some of the basic concepts of law as they relate to social media and online. So first question. Do you have a right to your own image in Australia? Can I control what happens to pictures of me that are taken and put up around the place? If you think that there is, hands on your heads. If you think that there isn't, hands on your tails. If you are unwilling to decide, I feel you. Okay, the answer is no, there is no right to your own image in Australia. If you said yes, please sit down. No Milky Way for you. So there is no right to your own image. There is, however, a restriction on using someone's image to promote something that they didn't necessarily consent to be promoted. I'm not sure who would possibly use an image of someone in an attempt to promote something. The legal letters are on their way to Ryan, Rubina, and Jen as we speak. Is training AI based on the dataset of the internet legal in Australia? Hands on the head, yes. Tails, no. The answer is no, it is not in Australia. I'm sorry, you can sit down. Wow, that weeded out a lot of people. Great, excellent. So I should say it's yet to be fully tested, but the answer is pretty much no based on what we know to date. And for those who don't remember last year, that is what you get if you look for an image of training Ask Jeeves. Is there a right to privacy in Australia? Heads yes, tails no. No. I Has that eliminated everyone? Wow. So was anyone who just sat down here in my past presentations? Because if you were, shame on you for not paying attention. Because I think I do that every year. So I might get you all back up, because I think there might be. Yep, there's one last question, I think, so this will hopefully only have one of you get it right. Are you responsible for what is posted on your social media pages? By third parties, I should say. Yes, you are, for now. Okay, that did not weed it out as much, but just to saying that, amazing, you guys both win a lukewarm Milky Way bar. So I will now attempt to break occupational health and safety laws by seeing if I can throw anywhere near as far enough. And the answer is no. So if you were wondering why I wasn't at the Olympics, that is one of the reasons. I'll try slightly better, and it's even worse. Okay, so that actually worked out well in terms of the number of questions, so thank you for coordinating with me beforehand. So let's get started and talk about privacy, everyone's favourite topic. Now, whilst there is no right to privacy in Australia as we speak, there is the Privacy Act, and it applies to certain people and organisations, so anyone with a turnover of $3 million a year or more, including individuals, so all of you high rollers, you are covered by the Privacy Act. People who are in the health space, providing a health service, which includes weight loss consultations, personal training, gyms, etc. Or if you are dealing in data, so buying and selling information. And it controls what you do about a bunch of other things. And to explain how we got to that point, where we kind of have this regime that sort of regulates privacy but sort of doesn't in other ways, I think it's useful to look through a bit of a recap of the history of privacy in Australia. So, as a society, the way in which we value our personal information has changed quite a lot over not a very long period of time in the scheme of things. If we look back to, let's say, pre-2006, I'm choosing 2006 as being roughly when people started to really get involved on social media. So, at that point in time, people generally would share a limited amount of information about themselves. So we're talking your MySpace page. You wouldn't have, the world's repository of information and misinformation in your pocket. And we had an appreciation for the value of our personal information and our privacy. We didn't just randomly give it out. Later in the piece, things changed a little bit. And we started giving away more and more of our information for convenience. If I wanted to sign up for something and they asked me for my details, I would hand it over because I wanted to get access to whatever it is that they needed that information for. And I remember, because my social media law journey probably started around about the 2012 period, and I remember talking to people at the time thinking, this is really interesting that we've now gotten to a point where people are willing to give over that information for pretty much points. Like, there was literally no tangible benefit, but we're giving it away because of convenience and prizes and because it seemed like it was easy, and sure, those corporations would totally be trustworthy. Now, this is an image that you get if you try to get an AI generation of a briefcase stuffed full of papers with a lock on it. If anyone wishes to buy me a briefcase, I would take that one. In 2014, the law started to try and figure out what was going on here because people were giving away more and more of their information. And whilst there has been a Privacy Act in Australia since 1988, it pretty much was toothless up until 2014. And so 2014 came around and we suddenly introduced the Privacy Act reforms that meant that the Information Commissioner could suddenly take control of things and impose fines if people weren't doing the right thing. And despite that, there was still, because of that perhaps, because people felt, okay, cool, there's a privacy commissioner now. They're going to keep us safe. People started giving away more information. And it was going from being innocuous things to being pretty sensitive things. And of course, those companies that we'd given the information to were very good at keeping it secure. And they were able to make sure that absolutely nothing bad happened-ish. as you'd all be aware, I mean, there were breaches before this, but these are the big ones. There have been huge data breaches in Australia. This is a picture. I want to highlight here that this is a picture of a person trying to get their personal information back at a help desk. I have no idea who or what the dark hooded figure is. I believe that my presentation is haunted and that we are all now cursed, so apologies. In the face of all of that, we've now gone from a position where everyone was pretty happily giving away their personal information, but then a lot of bad things happened. Hands up here if you've had your information included in a major data breach. Yeah. How much fun is it getting a new passport? Because of this, governments have now started to look at how can they better regulate things in order to protect our information more. And it is going to see a bit of a change in the requirements for businesses because of the changes that are coming through. So in 2020, a review was commissioned. It reported back in 2022. In 2023, the government gave a response to that report about what they probably would and probably wouldn't be adopting. And they've looked to adopt pretty much 80% of the recommendations that were made. And those changes are going to be significant, not just for individuals, but in particular for businesses, because it will change the way a lot of information is handled. So they're looking at introducing a criminal offence for a malicious breach of privacy. That is going to be significant because at the moment, and I don't know what's going on with the world at the moment, I had a bunch of inquiries on this recently, intimate partners sharing personal information that doesn't necessarily reach the threshold of revenge porn, but still is sharing information about their former partner's life, is happening more and more, and there's very little that you can do because that individual does not owe anyone a duty to keep the information private. So that is, I think, a well overdue reform. They're going to be massively increasing the penalties for breach. So at the moment, the penalties for a breach of privacy are around about the $2.4 million mark. They're going to be ratcheted way up, and they're going to do what a lot of countries have done these days, and it will be the greater of X dollars or a percentage of overall turnover for a given company. So that the Googles of the world, with love to Google, can't just say, okay, we'll cop the fine when 2.4 million might not be much to them. 10% of their Australian profits are probably a bit more. They're going to be introducing an online children's privacy code. Does anyone here market to youth? Yeah? Pay attention to that one because that is going to change the way in which you gather information and direct market to children online. We've already seen examples of this in the US. So the Children Online Privacy Act in the US regulates what information you're allowed to collect from minors and when you need to get parental consent and how you manage that. We're expecting to see something very similar come in Australia in the coming years to assist to protect children online. It'll also talk about what types of things you can market to them online by reference to personal information. This is the big change here, two massive changes. The first one is the government has in principle accepted that the small business exception, which says that if you have a turnover of less than $3 million a year or more, you don't have to comply with the Privacy Act, will be removed. So whilst at the moment, 3 million more is caught under is not, that will be just everyone is caught by the Privacy Act, which is great news for lawyers like me because we can now tell you, you have to have a privacy policy and a data breach policy and a privacy statement and a data breach management plan and privacy training for all of your team. But not so great for small business because that is going to be a lot of compliance cost. The government is consulting at the moment about what that's going to look like. So it isn't one that they've adopted in full, it's adopted in principle, subject to consultation. The other change that will happen is that at the moment, employee records are exempt from the Privacy Act. So once I have hired you for an employment position, I can do whatever I like with your information. I can sell it to the North Koreans if I like. I can do literally anything with your employment-related information. They are going to look to remove that exemption. which means that suddenly employees will have a lot more control over how their personal information is used. There's going to be a new obligation for a minimum collection requirement. So that's a bit similar to what we've seen under the European privacy law, the GDPR, which would mean that if you're running a promotion, for example, you probably won't be able to require people to sign up for further marketing communications. It'll mean that you have to get as little information as you can justify to run your competition, which will once again change the way in which we run a lot of marketing campaigns. They're looking to have a requirement of explaining why personal information is collected in an easy-to-read format. So that one's less good for the lawyers because we like making things confusing. And they will also introduce the notorious right to be forgotten, which currently applies for Europeans, where effectively you can say to whichever provider you like, please delete all information that you have on your system about me. Yes. I enjoy both questions and heckling, so feel free to throw it out. Excellent. Yeah. So the first question, I don't know if I quite heard it, but basically, how is it going to work in terms of protecting the images of prominent people? Yeah, so at the moment, if you're a famous person, how do you protect your image right now in Australia? The answer is in very limited ways. So the first one is under the Australian Consumer Law for misleading and deceptive conduct, where you effectively can say, you have implied that I support, endorsed, or in some way am affiliated with this business or brand, and I'm not. And that is misleading and deceptive. But it only works in the trade space. So if someone is representing that you have a particular political opinion, that is not covered by the Australian Consumer Law because that is not trade or commerce. In terms of images, you can protect yourself using, for example, copyright if you know the owner of the image. But beyond that, your protections right now are incredibly limited. And as we're going to see when I talk about AI, it's becoming even more problematic because it is much easier for people to put up very convincing imagery of celebrities, implying that they have taken a particular position or been involved in a particular thing. So the answer is that at the moment, not much, unless it's in trade or commerce. In terms of what we're expecting to see in terms of the level of compliance requirements here as opposed to the GDPR, I don't think it's going to go any broader than the GDPR, but I think it's going to come pretty close. Now, the government hasn't provided us with draft wording. They've only provided a response to the report, and they also haven't said when it's going to be implemented. So the reason why I had a question mark on that other slide at 2024 is that we don't actually know. So the next step is to be consultation with a bunch of people about some of the changes, small business, employer groups probably, and then they're going to start to implement them. So continuing on, there's also going to be an unqualified right to opt out of direct marketing, which is going to be pretty relevant. You're going to have a greater burden if you do direct marketing to demonstrate that you had that person's consent to sign them up in the first place. And so we're going to need to be really careful about how we explain direct marketing, newsletter sign-ups, competition entries in order to comply with that obligation. They're going to allow, for the first time, individuals to sue for breaches of privacy, because at the moment, if there's a breach of privacy, I can go to the commissioner and they can take action, but I can't personally take action for a breach of privacy. So that is going to change, and that is going to, once again, be really great for my business. So if any of you want to bring a breach of privacy claim, you know where to find me. And they're also going to be able to provide a tort of invasion of privacy, which means that there will suddenly be a different answer to my survey question. So maybe next time when we come here, if the government does something about it, those who had to sit down will be able to be in the running for another lukewarm Milky Way. Strangely, and I don't know if anyone else was shocked or surprised by this as I was, because I was rocked to the core, the report said that political parties who currently have an exemption from the requirements of the Privacy Act shouldn't have that exemption. And the government, as I say, absolutely shocked, said, cool, no thanks, and are not going to be bound by the Privacy Act moving forward because we're on the darkest timeline. So in the context of all of that, we then had another few interesting privacy sort of things happening. So one is that there was an inquiry into TikTok to see whether or not it was in breach of any privacy laws. And whilst the Information Commissioner said, TikTok be creepy, it is not necessarily in breach of any laws. So if you have TikTok installed on your phone, it does some pretty interesting things with your personal information, but nothing that is unlawful right now. So the legislative changes are likely going to be trying to address things like that, where technically, because TikTok tell you what they're doing with your information in like page 75 of their terms and conditions, they can do what they like. That will have to change when these reforms come through. Okay, so we're now going to move to the world of AI. And if anyone was wondering what it would look like if I and the Microsoft Paperclip had a child, that is your answer. It now will live in your nightmares, as it does in mine. AI has been a significant area of uncertainty in legal dialogue for the past 2-3 years. Which is interesting because AI has been around for a lot longer than that, but ChatGPT really blew things up. And one of the issues that we're starting to see more of is concerns in relation to people relying upon AI and then being liable for the consequences. Now, I'm sure you've all seen this, similar examples in the past, but I just love this so much, so I just want to share a little bit of fun that I've had with ChatGPT with you to explain why AI is not as intelligent as it seems. I asked AI how many N's there were in the word banana, and was told that there are 3 N's in the word banana. So that didn't seem right to me, I don't know. Double check, are you sure that's what it is? And no, sorry, 2. 2 N's in the word banana, great. Is that your final answer? Yep, absolutely. How about bees? AI, when it provides an answer, is not doing what you think it's doing. It is not actually going through the word and counting how many letters there are. It is looking through the internet, that wonderful source of completely accurate knowledge, and giving an answer based on the probability that this is what you're seeking to be generated from that question. And because of that, we are seeing people rely upon very convincingly stated statements by AI and getting into a lot of trouble. So in the case of Zhang and Chen, in Canada, a Canadian lawyer relied on ChatGPT to research a case. A bunch of case names were generated which looked super real with really legally looking citations, and he relied upon them. And when the other side said to him, could you please confirm that those cases are correct, he went back to ChatGPT and said, just confirming that these case names are right, and it said, yep, they absolutely are. And so he doubled down. None of those cases existed. And he was sued by his client, rightfully, for costs for for having relied upon fake cases in court. So lawyers are not smart all the time, and we're seeing that more and more. And so the law is now going to have to try and keep up with all of these very convincing fakes. And the other thing that we're seeing is biases introduced into AI which can have consequences for businesses from a legal perspective. So let's assume that you are using AI to vet candidates for a job. You may be using a system that has a very white English patriarchal standpoint based on the internet being a cesspool. And so, to give you an example, this is an image that you see if you ask for 3 lawyers at a conference table. I'll give them credits of having one female person there, but no diversity in haircuts. If we look for a powerful, successful lawyer, we're thinking, think about in your mind what that's going to come up with. And if you thought the whitest white guy who ever whited, you would be right. If we look for a timid lawyer, that's right, someone of color who is female presenting is shown. AI is based on very biased information, and whilst they are trying to correct for it, it is still a problem. And so if you use this to select which candidates based on the CVs that I've received should be put forward for this opportunity, you might be facing a discrimination claim because it will be tilted towards white men. So be aware that AI bias can have a legal consequence as well. So you might have seen, and you might remember when I spoke last time, that Sarah Silverman and a bunch of other authors are suing OpenAI for reproducing their works when they trained their AI model. There's been some pretty overblown statements saying, oh, that her case has been significantly narrowed. It was a procedural thing that happened. That case is still going ahead, and I think still OpenAI's got an uphill battle to demonstrate that their use of the internet to train their AI was lawful. If it were in Australia, it would almost certainly be unlawful. We've also started to see some rulings about whether or not the output of AI can be protected by copyright. If I create something online using AI, can I own the output and stop others from using it? So in Australia, you've got a case citation there that I did not generate it through ChatGPT to prove that I am in fact a lawyer. In Australia, they've said no one owns the IP in an AI-generated output. In the EU, same thing. In the US, same thing. In China, the opposite. Now, this is an interesting case where, and I've got that image there because that is the image in question here, where a person utilized stable diffusion AI image generation and over 150 prompts and negative prompts to create and refine that image. It was then reproduced by a third party, and the person who had done the prompts sued. And the Beijing Internet Court, which is the coolest court name of all, found that because there was so much refinement in the prompt generation, that this was in fact a work that required human skill and creativity. So whilst on its face it looks like it's completely divorced from everywhere else in the world, there is a potential argument to say that there is some consistency here. Because all of the other countries have said that there is no property in an AI-generated output because there is no human involvement or creativity in the actual creation. So if I type a prompt to create an image and do nothing more, it is unlikely that I can say that that has any IP in it. If I refine it and keep on altering the prompts to get a different result, I might in fact have an argument that I do own some of the IP in it. If you are generating images and you want to preserve IP in it, keep track of what you're doing to create it, because you may need to prove that you have refined that image, that you have made sufficient changes to actually be able to own it. We're also seeing a lot of work overseas to regulate AI. I'm going to go through this pretty quickly. The EU have a new AI law that's been put in place to try and regulate the creation of stuff from AI. and they've taken what's known as a risks-based approach. So effectively, there are certain things that they say you shall not and cannot use AI for ever. Those are up on the screen there, which is, most of those are pretty fair enough, especially the last one. And so in reality, we shouldn't be able to do any of these things. They've also then talked about high-risk uses of AI, and that is talking about instances in which AI is going to potentially pose some problems. And the thing that I found interesting about this is context is important. AI decision-making can be high risk in one instance and not the other. If I'm using it to decide what to have for lunch, we're probably okay. If I'm using it to control the safety mechanisms on a train or an elevator, that is high risk, and that is going to be heavily regulated under the EU rules. There's also limited risk, so things like chatbots, where the obligation is they're not going to be controlling how it works, but you must make it clear that the person is talking to an AI and not to an individual. So you shouldn't have to guess whether or not you're talking to a human. You should know immediately that you are or aren't. And then things like AI-enabled video games and spam filters will have no restriction or regulation at all in the EU. There is discussion at the moment around the place in Australia about adopting a similar regime, and that's why I wanted to raise this. Because if you happen to work with any of those industries, it could be relevant. If not, it's pretty light on. And that's because a lot of organizations, and a lot of countries, I should say, are trying to balance investment in AI and not being behind the eight ball when it comes to it with the fact that we're in the darkest timeline. And so how do you encourage investment without everything going to hell? Now, I want to give you a bit of an update on defamation in the last few minutes that I've got. So everyone here remember the Dylan Voller decision? Anyone willing to tell me what it means? Excellent, I'm glad I've scared you all into silence. The Dylan Voller decision, for those who don't remember, was the case that said that you are responsible for what a third party says on your managed social media page the moment it is published. So if I come onto your company's Facebook page and I make a comment that is defamatory, even though you didn't expect me to put it there, even though you didn't know I was going to do it, you are responsible the moment it pops up online. So the key takeaways of that one were publication happens the moment it is online. If you have encouraged people to comment in any way on your pages, you are responsible, and the news publications were responsible for what had occurred there. Now, we are looking at some reforms that have come in to try and change that position. And this is going to be, I think, pretty relevant if you have any community management as part of what you do. And I apologise to both Mr. Voller and Gwen Stefani for that terrible image. They're introducing a new defence for digital intermediaries and also for search engines. And effectively will say that if you publish defamatory content because someone comments on something and you didn't know or shouldn't have known about it, and you provide a mechanism for people to have it taken down rapidly within at least 7 days, no more than 7 days, you will have a defence to being responsible for that publication. Now that has some limits. If you have put up an image of me and said, give him your worst, and encouraged people to come on and make defamatory comments, you're not going to be able to use this. This is really intended to cover situations where you didn't expect. I made a post on the weather and Ed commented on how terrible my presentation was. That's the kind of thing that this will cover. But it is worth knowing about. The other thing, though, is that for the first time in a long time, we are now having differences in views from state to state. Because those defences that I've just raised, other than in relation to the aggregation and search engines, has been rejected by South Australia. So we're now going to have a situation where you might not have been, you might have a defence if you're in New South Wales, but not in South Australia. And I'm not sure if the legislators have realised this, but the internet kind of is accessible across the country. And as a result, if something is published in New South Wales, it's then read here in Adelaide. So a lot of cases are now going to be coming, I would expect, to South Australia. Once again, thank you, politicians, for helping me with my career. I want to give you this case is interesting in a similar sort of way because it kind of goes against Voller in a way. And this was a case of Hoser and Harrison, and if you ever just want a giggle at a court case, it's worth looking this up. And I've got a long quote there that I'm not going to read out, but basically it was between competing hepatology buffs, so snake enthusiasts, and it was about whether or not one or other of them was entitled to call themselves Snake Man. It is wild what happened in that case. But Mr. Hoser sued Mr. Harrison, but he also sued Meta for comments that Harrison had made about him and the fact that he shouldn't be able to call himself Snake Man, as he's not a true Snake Man in some way. And unlike in the Voller decision, it was held that Meta, having no idea about this going on, having not in any way encouraged it, weren't responsible for what had been posted. So it was a really interesting, that this is before any of those reforms came in, the courts are starting to inch away from the Voller decision and come back to the position that we had before then, which is you're only responsible once you had reason to believe that the information was there, which I think, to be honest, is a much more sensible position. Now, we're almost at the end of time, and so this is going quite well. So let's just have a quick chat about our good friend Elon. Not sure if anyone saw this, but apparently the bastion of free speech was very upset that people decided not to advertise on his incredibly hate-filled platform, and therefore has sued them for their coordinated campaign of not advertising on X. I wish him luck in this endeavour and hope that it costs him a lot of money. We'll see what happens there, but it's quite an odd and outrageous claim. X did have a bit of a victory though. So you might have seen that the eSafety Commissioner took action against X for failing to take down the video of the stabbing of the priest in New South Wales a little while ago. There wasn't a decision made in the case by the court. The Commissioner dropped the case after the victim of the crime who was filmed expressed that he didn't really mind that the video was up there. But there was quite heated court discussion by the parties as to whether or not the eSafety Commissioner, who has an obligation to keep the internet safe in Australia, could force a multinational to take content down. And we still don't know the answer to that. The laws are there, but they are yet to be properly enforced. Now, last bit of audience interaction. Who here has now or in the past ever signed up to Disney+? Cool. I do hope that nothing bad ever happens to you if you go to Disneyland. But why do you think I would suggest that, having raised that, you should read the fine print? I think it's a great sleep aid. It gives validation to lawyers who really need it. There are often fun hidden Easter eggs in terms and conditions, or corporations are pretty much evil. Anyone think it might be answer D? Yeah. So you might have seen this story in the news, but basically, and I make light, but it is actually a tragic situation where a woman died in a restaurant in one of the Disneyland theme parks, and her husband has sued Disney for wrongful death. Although I think they're starting to walk away from this based on the public backlash, Disney argued that the husband was not entitled to bring a claim in court against them because when he had signed up for a 30-day trial of Disney Plus some years beforehand, he agreed to terms and conditions in the click wrap, so the online terms and conditions, that said that any dispute between him and Disney needed to go to arbitration and not the courts, and it was subject to a whole bunch of limitations. That argument is silly for various reasons. Firstly, it's morally repugnant, but secondly, because he wasn't bringing the action himself, he was bringing it as the executive of his wife's estate. But the point that it does raise is that these long terms and conditions that pretty much I think I am the only human in the world to have read some of, can theoretically have these consequences. And so this is likely to bring regulators to a position of requiring those terms and conditions to be shorter, to be simpler, and to be more fair. And we've seen that here in Australia because as of November last year, the government brought in new reforms to the Australian consumer law that mean that not only are unfair contracts like that unenforceable, so you can't actually stand behind them, but it's also an offence to have a contract that has unfair contract terms in it. And there are monetary penalties for this. So if you have competition terms that say that you can force people to arbitration if there's some kind of other dispute, that could be a problem. If you have a privacy policy that says you can change it unilaterally and it's the responsibility of the person who is giving you information to check, that is likely unfair and possibly an offence. A lot of the contracts that have been pretty much standard form across business over the past 30 years are now likely to be unfair contract terms and may well have an issue for anyone trying to rely upon them. Not only that they can't rely on them, but that they might have committed a breach of the consumer law with a penalty and a fine. So on that point, I think, am I good for time to go to questions?
Yeah, let's do it. Thank you, Paul. Assuming theoretically I recorded your whole presentation there and I'm going to chuck it online this afternoon, who owns that?
So the laws for a video recording is the producer of it. So that will be whoever paid for the commissioning of that video to be made.
Oh, so we own you, basically.
You do. You do.
All right, cool. There's an AI-generated Paul Gordon OnlyFans starting up this afternoon as well, just in case anybody here is into that. It's a thing. A couple of questions from Slido. Graham has asked, if your Google ads get wrongly rejected for legal reasons and customer service can't help, what is the best approach to resolving the issue with Google? And who's legally liable for that?
So Google's terms and conditions pretty much say that they're not for any mistake that is made and they're not liable for any loss. That is probably an unfair contract term, which means that it can be challenged. If you wanted to get legal, you could effectively say that they have acted in breach of their own terms and you could seek a court order to force them to do things. In reality, though, who has the time or money to do that? I think that if it's happening over and over again and it is really harming your business, then it might be worth contacting basically a sternly worded letter can do wonders. I've found with Google in the past. But unfortunately, other than their appeal mechanisms, they take the business model that it's too hard for anyone to challenge this, so they won't.
Can I just say, if you want a sternly worded letter, Paul Gordon's very good at those. I have used him many times for sternly worded letters. Gives out some good advice. Evan has asked, how much does the right to be forgotten stretch to anonymous or pseudo-anonymous identifiers such as web browser cookies, device details, or a fingerprint on a device?
So it doesn't extend to anything from which an ordinary person couldn't identify you from. So the character of information changes by who has it. The easiest example I use for this is a license plate. If you give me a license plate, I can't tell you who that's connected to, but someone with access to the motor vehicle registration registry can. So if I was given a license plate, that the right to be forgotten doesn't apply because I don't know whose that is. If, however, I do have access to re-identify it, then I would have an obligation to remove that record. So when it comes to device settings, I would say that unless you have a very accurate IP address identifying technology that can pinpoint the individual, you don't have to worry about any of those types of things. It's only information from which the identity of an individual can reasonably be ascertained.
Another question coming through anonymously. What defines an unfair contract term? Okay,
so the law is pretty broad on this, and so which is unhelpful, but they've given some examples. Things that are unilateral or one way, so if I've got a clause in there that says that I can choose to terminate the contract but you can't, I get an indemnity, so if something goes wrong, you have to cover all of my costs, but it doesn't go in the other way. The contract automatically renews if you don't tell me you don't want it to a month beforehand. All of those have been said to be likely unfair terms. And that last one can be a pretty big one if any of you are involved in SaaS or even just marketing subscription. you need to inform people before the cut-off date for them to terminate if you want to be able to rely on that clause, because if you don't, it's likely unfair, they can get out of it anyway, and you may face a penalty.
All right, one final question before we let you go. How do people keep up to date with the latest privacy policies specifically for marketing?
So there are a few resources out there. The Privacy Commissioner, if you go to oaic.gov.au, they've got some good resources there. As these things are developing, there will be different things posted by the various peak bodies. If you want to, I will be, if you follow my socials, whenever there's a privacy update, I will be posting about it, and I'm always happy to have just a chat with anyone or a coffee to discuss how it might apply. Basically, just have to watch people who watch the space is the best way to do it.
So we'll watch you, and don't forget Paul Gordon's OnlyFans will be kicking off this afternoon. Thank you, Paul.
Thank you.